denial of his petition for post-conviction relief, which was based on ineffective assistance of counsel. Mr. Cartwright was tried. The trial ended February 6, 2016, where he was found guilty of 2 counts of one count of assault, domestic assault, another count of aggravated assault. The domestic simple assault was based upon the incident of April 15, 2016, and the June 19, 2016 incident was the basis of the aggravated assault. In this appeal, we have focused primarily on the June 19, 2016 incident, based upon the fact that the court had, it was a misdemeanor for the first count 1, where it was 11-month, 29-day sentence. In that case, that count, obviously, he was found guilty on a lesser included offense of simple assault. He was sentenced to 14 years to serve 45% on count 2 on June 9th, 2018. So the issue in this case is whether the trial counsel in this case failed to investigate, locate, and subpoena witnesses that were material to the defendant's defense, wherein there were witnesses such that would have assisted the court in determining whether the defendant was innocent or guilty. Essentially, there's evidence of witnesses that directly contradicted what the victim alleged.
Were they eyewitnesses?
Mr. Ontario Pratt testified in the post-trial conviction hearing that he witnessed the incident occur on June 19, 2016. He was present and offered a different a view of what occurred than the victim, essentially saying that the victim, alleged victim, was the initial aggressor and tried to hit Mr. Cartwright with a brick, and then in that process, Mr. Cartwright pushed her, and she fell back and hit her head on the brick, causing her injuries.
Okay. Was that consistent to what the defendant said?
It was consistent with what the defendant said. For the most part, there may have been some technical differences in whether he saw her fall and hit her head on the brick or not. I believe the defendant testified that he took his eye off of her for a second, and when he turned back around, she was trying to hit him with a brick, and he pushed her, and she fell. I don't believe that the defendant testified how the injury occurred, or that he saw how the injury occurred, whereas I think Mr. Pratt did. I think the other difference, which the state pointed out in the court at the post-conviction level found, was that there's a difference between what Mr. Pratt testified to subsequent to the injury, where he testified that the victim left the scene and got into a car and drove away, when the defendant and the proof showed at trial that she remained there on the scene, on the ground, and left in an ambulance.
I got the impression from reading, I guess, either the order or the briefs, that the post-conviction court found this witness to be incredible, and from these inconsistencies that there might have been some collusion, post-trial collusion between the two, the petitioner and this particular witness, because there were so many, not so many, there were inconsistencies with his version of the events, and that's why the post-conviction court denied relief in this case. Can you speak to that?
Yes, Your Honor. And the order does not precisely state those findings in the way that, Judge, that you have here. However, I would agree that it appears from a careful reading that the court was concerned about the difference in the testimony and some other things that the witness said. And I think that's one of the issues that we're putting forth before the court, is that we think the evidence preponderates against that implicit finding.
How do we deal with that when the trial or the post-conviction court here has made a specific credibility finding regarding this witness?
Well, I think that's one of the things that I was trying to point out is that I don't think the court specifically made those findings. It appeared to be implied in my reading of it based upon the fact that the court said that the court accredited the testimony of the trial counsel. The court pointed out that there was differences between the testimony of Mr. Pratt that contradicted the testimony of Mr. Cartwright. But I, in my reading of it, did not see a specific finding. I reviewed it again this morning, I believe, that the court specifically said that I never saw the word collusion.
I agree. That's my word. That's my word, and I can take it back, quite frankly. But there's a credibility finding against this particular witness.
I'm not sure that I saw the word that the court specifically stated that he was not credible, but the court did specifically state that they accredit the testimony of trial counsel, that he investigated the witnesses, and that he would not have put on a witness that he felt contradicted his client.
So you think there's room there, even though the post-conviction court denied relief in this case?
I do think there's room there, Your Honor, because of course, I think Strickland versus Washington stands for the proposition that we cannot really go back and reweigh this and retry this case and speculate on what counsel should have done in that context. In general, we have to look at it at the time that the decisions were made. And in this particular case, I think the room that the whole, I guess, or what we're trying to traverse here is that the trial counsel does not recall making even a call or speaking with any of these witnesses. He doesn't have, and that's the other, I think, problem with the findings of the court is that how can the trial counsel be accredited? How is he accredited with his version where he never stated that he even spoke with the witness? That he has no recollection of it. His statement was general in that it's always my practice to talk to the witnesses. But there's nothing specific about, yes, I spoke with Mr. Shai Henderson about these list of witnesses and names that he gave to me. There's nothing specific about that. And on the other hand, Mr. Henderson testified directly. I spoke with the counsel and I gave him Ontario Pratt's name and I gave him two other names who are now deceased. So there's no ability to go back and get those witnesses, they are deceased. There's no way to present that evidence, which leads to the prejudice in this case. Because there's no inability to get the witnesses to testify or to bring them forth to the court, even on a post-conviction because they're now deceased, and offer their testimony. And also the fact that the witnesses that Mr. Pratt that did come to testify at the post-conviction hearing, some 8 years after, my math ain't being correct,
It's okay.
but many years after the event, his recollection is obviously not going to be as clear as it was. In addition,
The trial court didn't, I mean, the fact that the trial court considered the testimony of Mr. Pratt and did not, even though it wasn't explicit, did not explicitly accredit the testimony of Mr. Pratt. So how are we supposed to view that testimony? I mean, I want to applaud, were you PC counsel?
yes,
I absolutely applaud you for actually bringing the witnesses. This court often sees these PC cases where witnesses are, put forth as would've, could've, should've, but the PC counsel, they fail to bring those witnesses. So I do applaud PC counsel here for actually putting forth the witnesses in connection to the ineffective assistance claim that trial counsel did not contact these particular witnesses to demonstrate what they would have testified to at trial. I guess the problem becomes that the trial court said even if he had done this, or didn't say this, but implied this in its order, even if this witness had testified, their testimony was inconsistent with what the defendant himself testified to.
Yes, Your Honor. And one of the things about that is even the trial counsel points out that he did not want to put his client, Mr. Cartwright, on the stand because of his criminal record. So one of the issue of prejudice is also in that having the witness to having an eyewitness that gives a version of the events that contradicts the accusations of the state gives the defendant the option, a good option, to not have to testify. Because in this case was so clear as it being a he said, she said, there's only two really versions of what has occurred. There's no denying that Mr. Cartwright was there. It's not another person other than these two, was one of these two people involved. And the victim here has no clear recollection of what occurred. Her testimony was inconsistent. She admitted that she lied. She was under the influence of Xanax, a pint of alcohol. She said she blacked out numerous times during the incident. So another version.
And the jury's still convicted.
And the jury did not hear from Mr. Pratt.
And then remind me, counsel, did the defendant at trial testify that she was the initial aggressor on the second incident?
That is my understanding that he did. My review of it is that he did. But again, the harm, the prejudice in him being, the issue of him testifying and his criminal record being used against him is concerned trial counsel.
To what extent was
that.
he, I'm sorry to interrupt, but to what extent was he impeached with his criminal record at the trial?
It was introduced. He was cross-examined on that. There's no definitive way to, I think at this point, to determine how much the jury relied on that fact. But even trial counsel in his testimony at the post-conviction hearing stated that it was a concern of his. It was a concern of his throughout the case because the defendant had a significant criminal history that involved violent crime. So that would be a serious issue for the court, for the defendant in that case, for the trial counsel, such that it would be very important to be able to offer another version without having to put on Mr. Cartwright as to testify in this case. So this is a fairly straightforward case, although it is very important, and it turns on obviously issues that are related to post-conviction that put the defendant in a hard position to be able to have relief here. But the appellant urges this court to view the evidence and find that the testimony of Mr. Henderson and Mr. Pratt establishes that the trial counsel was deficient in not investigating and contacting the witnesses. And one of the things that I think is clear about that, it's not, when I say clear, I mean as a practice of counsel in a case going to trial, you're not, when you're investigating, you're not just calling and talking to the witnesses in general. You're going to have to help develop the witnesses, meaning that it's important to discuss what happened with them and so that you know how to prepare your case and present the witness at trial. And clearly, in this case, that wasn't done. He wasn't presented. Neither, and the other thing is the court found that Mr. Henderson's testimony, because he was not an eyewitness, possibly would not have been admissible. But it appears to me from his testimony about having had experience with the victim and the defendant and her propensity for being drunk and making accusations and getting into fights, that there was a possibility that Mr. Henderson's testimony regarding an opinion or her reputation may have been admissible at trial as well. So we're asking that the court.
Did you argue that? Did you develop that below for the court?
I don't know that I stated in the argument section of the hearing that point, but the testimony of the witness during the hearing is that he was familiar with them. He had known the defendant since he was 12 years old, and that he was familiar with this relationship and had seen her many times. And that information factually is in the record from the post-conviction hearing. I don't know that I stated it directly as I have stated it here during that hearing. But we're asking the court to make that finding and find that we have met the burden on both prongs as outlined in the Strickland case.
Thank you.
And I'd like to reserve two minutes. If I have 2 minutes.
All right, thank you. Mr. Douglas.
May it please the court. Good morning again, Your Honors. Davey Douglas on behalf of the state. And we would ask this court to affirm the judgment of the post-conviction court because the petitioner has not established that trial counsel's performance was deficient or that it caused him any prejudice. Turning to the issue of deficiency, trial counsel testified that he would have tried to investigate and contact all possible witnesses. And even the petitioner said that trial counsel told him that he had contacted Mr. Henderson and Mr. Pratt and told him that he didn't think they were suitable witnesses and wouldn't have called them at trial. And then trial counsel said...
Did he specifically say that he did not think they were suitable witnesses?
That's what the
Mr. Henderson and Mr. Pratt?
I believe that's what the petitioner said. I don't know that he identified them specifically by name, but he said that trial counsel told him that he had talked to the witnesses and that trial counsel told him that he was not going to call them at trial. And that was sort of echoed by trial counsel's credited testimony where he said it was possible that he talked to Mr. Henderson, but he said he would not have called him had he not witnessed the altercation. And that's what Mr. Henderson's testimony at the PC hearing bore out. He admitted that he was not there for the June 19th altercation. And the post-conviction court did specific...
I really thought that the purpose of Mr. Henderson was to establish the link between trial counsel and any other potential witnesses that were actually eyewitnesses, not who came to the scene shortly thereafter, which was the case with Mr. Henderson.
I thought it was twofold. That first, he really was arguing that trial counsel should have called Shy Henderson to testify because he could have testified somewhat, I guess, to the degree of the relationship between the petitioner and the victim. But, and this sort of goes to prejudice, that's where Mr. Henderson's testimony would have been problematic in that his account of the relationship between the petitioner and the victim did not match up with the petitioner's own account. Mr. Henderson said that the petitioner and victim really didn't have a sexual relationship, while the petitioner said the victim was just someone that he had sex with. So you've already got that inconsistency there. But then I do agree with you, Judge McMullen, that part of the reason, too, that there was the issue with Mr. Henderson is that he gave these other names, including Mr. Pratt, allegedly, to trial counsel. And again, we have trial counsel's credited testimony that he would have tried to investigate and contact anybody who was an eyewitness to the June 19th altercation, and that he wasn't able to find anybody who he thought was a suitable witness. But then we get to the substance of Mr. Pratt's testimony itself at the post-conviction hearing, and as was addressed in the opening argument, the post-conviction court implicitly rejected this testimony as not credible, which is, again, supported by the record because Mr. Pratt's account of the June 19th altercation and the victim's injury had several key differences.
What's problematic to me about this case is that the victim herself admitted that she was pretty strung out on either drugs or alcohol or whatever the case may be, and in large part admitted that she kind of pursued the petitioner. And so that's what's problematic about the implicit credibility determination of the trial of the post-conviction court. So can you speak to that a little bit for me?
Certainly, Your Honor, and I would agree with you. Yes, the victim did have some aspects of her testimony where she said she couldn't really remember, but there was also aspects of her testimony that didn't inculpate her as sort of the complete instigator and provide the petitioner self-defense. And the jury still, hearing these inconsistencies in her testimony, the evidence about her substance abuse, they still voted to convict the petitioner of aggravated assault as charged in that second count. And
The second count, and remind me if I'm wrong, correct me, where she said she didn't know who hit her. All she knew was when she looked up, the defendant was there. She didn't even identify the person who apparently struck her, which was also problematic to me in reading. Was that the first incident or the second, the brick incident?
that was the brick incident, and she was a little equivocal. She said, I'm not going to say it was him, but I'm not going to say it wasn't, but I was arguing with him, and then I saw a white flash and woke up on the ground. And nothing really in her account supports Mr. Pratt's version that essentially she hit herself in the head with a brick and fell to the ground. And then we get into the further inconsistencies.
I think I don't know if Mr. Pratt said she hit herself in the head with the brick. The way you characterized that, I didn't get that. I got that she fell back and the brick hit her in the head. The brick that she was throwing at the petitioner's car with the petitioner in it, or at the petitioner. So I just want to be fair to the characterization of the proof in this case.
And certainly, Your Honor, I do not intend to mischaracterize anything. That was how I read Mr. Pratt's testimony, though, that she fell backwards and hit herself.
Yes.
But I acknowledge there are other readings of that as well.
Okay. Yes.
But you have Mr. Pratt saying that she got up and got into a car and then left the scene, and that he didn't see what the petitioner did afterwards. That's directly contradictory to what the petitioner said. He said that he was...
Can you speak to the time frame again in terms of when the post-conviction hearing was versus when the actual incident occurred?
So the actual incident occurred, I believe, it was June 19th of 2016, and the post-conviction hearing was in... I apologize for not being able to recall the exact date. It was 2020 or 2021. There was some time that had passed.
Just wanted to be clear on that. I think I heard counsel say something like some years. I just didn't know why so much time had lapsed between his conviction. Usually there's a year after to get the witnesses in. Can you speak to that at all? I know the record may not bear that out.
I don't think the record really does bear that out entirely. I think there were just sort of some normal continuances, some delay, some time for the appointment of counsel and the filing of the amended petition. I think this is sort of speculation. I think it could have been some difficulty, maybe some additional time needed to track down these witnesses, to talk to them first and then to get them to the hearing. But Mr. Pratt seemed initially, when he was testifying on direct, pretty confident about his recollection of the events. And even the petitioner had to agree that Mr. Pratt was wrong about some things. And trial counsel testified that he would not have wanted to call somebody who had a different version of events than the petitioner. He thought it could have been.
Would you agree with me that trial counsel was just given kind of a general, his general practice, his general view of how he handles cases, and didn't really provide any specifics?
I think that's accurate, Your Honor. I think he was speaking more in generalities, but he did actually specifically address Shy Henderson. He said it was possible that he talked to Shy. And I don't know specifically that he said Mr. Pratt, but he did specifically say it was possible he talked to Mr. Henderson. And he heard Mr. Henderson's testimony, too, and said he wouldn't have called somebody who didn't witness the altercation. But when we look at trial counsel's credited testimony about the steps he took to investigate, and then the fact that neither Mr. Henderson nor Mr. Pratt could have actually provided a beneficial account of the events that would have helped the petitioner. He has simply not demonstrated any deficient performance or any prejudice. And so unless there are any further questions, we would ask this court to affirm the judgment of the post-conviction court.
Is it not helpful to the petitioner, though, that Mr. Pratt would say that the alleged victim here fell and the brick hit her on the way down, specifically given the somewhat vague nature of her testimony at trial on that particular incident?
In a vacuum, yes, I think it could be helpful, but that would be coupled with his testimony that completely undercuts the petitioner's version of events about what happened afterwards, about seeing the victim get into a car and leave when the victim, it was clear that an ambulance came and took her away. I think those big discrepancies really would have undercut any credibility that Mr. Pratt had.
Is that I mean, it's a discrepancy, but is that a huge discrepancy that just completely undercuts anything that Mr. Pratt has to say about the actual attack and the event?
I think it is, Your Honor, because the victims leaving the scene and the petitioner leaving the scene happened pretty shortly after the actual attack occurred. And so if we've got Mr. Pratt providing the version of the attack, but then he's wholly contradicting the petitioner's version of events of what happened shortly thereafter, I think that really does call into question his version of the events. And again, we still, while it was not a complete model of clarity, we still have the victim's testimony herself that the jury was able to hear.
So are you saying that it was a strategic choice of counsel not to call somebody whose version may contradict even on a non-material issue?
I think it could be, Your Honor. I think, again, his testimony about how it would have negatively impacted the defense shows that he did possibly make a strategic decision regarding the witnesses. But I have to admit, too, that he did not specifically recall talking to Mr. Pratt. But I think there are strategic elements to the choices that trial counsel made here.
I guess his general strategy, what he considered in whether to call a witness.
Yes, Your Honor, absolutely. It does go to his general strategy. And his general strategy was if someone didn't witness the altercation or was going to contradict the petitioner, that would not be a witness that he wanted to call. And that's the category that both Mr. Henderson and Mr. Pratt fall into. And so the petitioner has not shown that counsel was ineffective regarding these two witnesses. And we would therefore ask this court to affirm the judgment of the post-conviction court. Thank you.
Thank you, Mr. Douglas. Mr. Stover.
In trying to address some of the issues that have come up since I was last at the podium, I think the hearing on the post-conviction petition was April of 2022. The order denying the post-conviction petition at the trial level was entered May 18, 2022, as the judge had taken it under advisement and issued a written opinion at that time.
The conviction occurred in what year?
The conviction was in.
I'm sorry, the offense.
The offense occurred June 19, 2016.
Okay.
So I believe we're essentially 6 years. I think I may have said 8, but it's 6 years, approximately 6 years after the event had occurred is when the testimony was entered with Mr. Pratt and Mr. Henderson. And I think that, one of the things, I've tried a few cases, and, one of the things that you ultimately, find is that no witness's account is going to be 100% accurate. It's just almost impossible. There are going to be some differences that are just going to be inherent in just the fact that people, one, see things differently. They can see the same thing, and some people might see a little bit different aspect than another person does. And sometimes people forget some things, or they may pay attention to something more than other things that someone else may have paid attention to. And the other thing that's very important in this situation is that the defendant has a right against self-incrimination and does not have to testify, and typically, in most cases, probably does not. And the fact that he does not testify cannot be used against him. And in practice, typically, the defendant would be the last, if you're going to put on a defendant, would be the last witness that the defense would present. Because, first of all, the state has a burden of proof, obviously, and by the time you get to the defense's proof, you're going to probably say that testimony for last as a practical matter, and that's usually what occurs. So, in this particular case, had trial counsel called and spoke with Mr. Pratt, developed the evidence with Mr. Pratt as far as, I'm not sure that there would be anything wrong with him, going over the incident. He would obviously ask him what occurred and discuss it with him. In other words, I guess what I'm trying to point out is that the only way there would be a contradiction to the defendant's testimony is if the defendant had testified. And what I'm asserting here is that part of the prejudice is that the defendant had no other alternative but to testify because trial counsel did not contact and bring forth a witness that was an eyewitness to the event. And the fact that there's a distinction or a discrepancy into a version of the event that about what happened afterwards, after the fact of this alleged aggravated assault, is not the crux of the matter. It's not material. The material aspect is who caused the injury, who directed the action that caused this injury. And Mr. Pratt's testimony would have demonstrated that it was not the defendant. And that would be critical to the defense. So the fact that he did not even call, or there's no evidence, he can't remember, and the evidence that was produced by the defendant shows that he was given the information, the contact information, and he never made the call. Thank you.
I think we understand your argument, counsel. The case will be taken under advisement. I think that concludes our docket for the day. Am I correct in that, Madam Clerk?
Yes, Your Honor.
All right, well, this court stands adjourned until the next session.
All rise.
Court criminal